All the information that you gather in preparation for applying for your court order or your search warrant must be checked against other sources of information, including records held or accessible. Sometimes the information needs to be graded to determine the weighting that it will be afforded based on reliability or unreliability of the source where the information comes from. When you collect information, you're establishing reasonable grounds to suspect. You need to be able to provide sufficient factual information for the person issuing the search warrant or court order, the justice or the magistrate, to independently form the opinion that the person or the things that you are looking for are in or on the place that is described. Now, a common misperception with a lot of people when they're preparing affidavits for search warrants is that because you're investigating a crime, people think you have to prove your reasonable grounds to suspect beyond reasonable doubt, as is the criminal burden of proof, but that is not the case. Your affidavit in regards to your application for your search warrant or your court order is based on a reasonable person test. So it's balance of probabilities, which is the civil burden of proof, and you only need to be able to prove that the person or the thing you're looking for is in or on the place you described. When you prepare the affidavit, the investigator or compliance officer making the application must take all reasonable steps to ensure that the information is accurate. So if you can corroborate the information in as many different ways as possible, you can ensure as best as you can that the information is accurate. You must also ensure that the information is recent. Sometimes in protracted investigations, you may not execute search warrants until the end of the investigation or towards the end of the process of the investigation. If it's a complicated matter and there are a number of people who are offenders involved in it, you may not execute the search warrants for 6, 8, 9 months after the investigation commenced. So any of the information that you got back at the early stages of the investigation, that will need to be rechecked. So the information has to be recent. If you go to the magistrate or the justice and you have information that's 6 or 8 months old, I would guarantee the justice or the magistrate will ask you, is that still the case? Can you check that and come back to me? So any information that you get in the early stages of the investigation must be rechecked before you make your application. The other thing you've got to look at is sometimes some of the information you'll get will be provided maliciously, or there'll be some sort of background agenda with the person who gives you the information. This may be through personality conflict, it may be warring neighbours, it may be an ex-spouse, you don't know. So any information that you get, you must try and corroborate it. Any anonymous information has to be corroborated independently. The days of using anonymous information are gone. When you make the application, you collect all your information together and you basically put it together very much like a brief of evidence. You put the documents together in a folder, you put an index on the front of them so that when you go to the magistrate or the justice and they ask you questions, you can go to the document that you need to refer to when you get that question asked of you, and it has to be put together in an orderly and logical manner. The information needs to be easily accessible. When you go and make your application for your court order or your warrant, you will swear an oath or an affirmation. Generally, it'll be something along the lines of, I swear by Almighty God that the information contained in this warrant application is true to the best of my knowledge and belief. 2 additional areas of the oath may be, I will answer questions put to me in relation to the issue of the warrant. Sometimes if you are a regular person that attends the magistrate or the justice and you have a history of being honest and truthful when you make your applications, sometimes the magistrates or justice may allow you to prepare the warrant application and sign the affidavit before you actually go and see the magistrate or the justice. If that's the case, you will have an additional part of the oath that says, if the warrant's signed, the warrant application bears my true name and signature in my handwriting. When you've obtained the warrant, you will have the original warrant in your possession. You need to have that as the warrant holder or the person taking out the warrant or court order. You need to have that in your possession when you go to the premises to execute the order or the search warrant. You need to, as soon as possible, introduce yourself and identify who you are as soon as possible and explain the purpose and the process of why you are there. The best situation is to ask the owner or the occupier or person in charge, which is the standard wording for warrants, that you are there to do a job, and ask their assistance because you have an order from the court that allows you to undertake these inquiries, conduct a search, or enter the premises for the purpose of inspection. You also need to adopt a calm and considerate attitude throughout. It is often the case when you execute a warrant or a search order, a search warrant, the person will be upset, and sometimes they get volatile and get aggressive. You have to remember though that you have a document from the court authorising you to undertake the actions when you attend the premises. One thing to be careful of is to not unduly restrict the movement of the occupants of the premises unless they are hindering, obstructing or threatening. Usually where there's a search provision in a piece of legislation that you are administering, there will be immediately under that an area to get emergency warrants, and then straight after that generally you will have paragraphs in the Act that require the person to cooperate when you attend to execute the search warrant. They commit an offence if they unduly restrict, hinder or obstruct the movements of the authorised officer when executing the search warrant. You cannot arrest people when you attend to do search warrants and court orders. It is a very serious thing if you make someone sit in the chair, for example, and don't let them move in their premises. If they're not restricting, hindering or obstructing, they're not committing an offence, and you have no grounds to arrest someone. The legislation that you administer as a government investigator does not provide you with the ability to arrest people, so you have to be careful. Many years ago in Victoria, a group of detectives from a squad executed a search warrant, and they made a person sit on a chair, and every time he got up they pushed him down on the chair. After the warrant was executed, that offender or suspect successfully sued the Victoria Police Service and was paid compensation for an unauthorised or an illegal arrest. When you attend the premises, sometimes you need to use force to gain entry. It's force to gain entry, force on the property, force on the locks. It's not force on the person who's the owner, occupier or person in charge. You need to cause the least amount of damage where you can. Sometimes you may need to cut a padlock on a gate, or force open a door, or force open a filing cabinet, or similar. But try and cause the least amount of damage as possible. The easiest way, coming back to when you arrive at the premises, make a request for admission, make a request from the owner, occupier, person in charge for them to cooperate and open the door, the gate, the lock, the filing cabinet that you want to have a look in. When you arrive and you introduce yourself and explain your purpose, you should hand the owner, occupier or person in charge a copy of the warrant. You need to have the warrant with you. You can't leave it back at the office. It needs to be in your possession when you attend the premises to execute. And The original warrant needs to be protected at all times. The original warrant needs to be re-examined when you go to court in the final court case, and you need to have that warrant. So when you go to court with a warrant, when you come to give evidence about the court proceedings and your investigation and all the evidence you've collected in regards to the commission of the offence, the warrant will get revisited. So the reasonable grounds to suspect that you used to establish those reasonable grounds to suspect with the justice or the magistrate, they will be revisited in court. So you still then have to be you will be cross-examined in relation to the contents of the warrant and your application and your affidavit. The reason why you need to keep a copy of the original warrant is because it may have specified conditions on it. It may have terms and conditions of when you execute the warrant, how long the warrant's in existence for, when it was issued, when it needs to be executed by. Generally, warrants will be around about 72 hours. Usually, when a warrant's issued, it needs to be executed within 72 hours. Sometimes you may not be able to execute that warrant within 72 hours. In that case, when you reach the end of the 72 hours, you go back to the court and get another warrant with an extension of time. So it's a second warrant separate to the first one, but the first one expired because it couldn't be it couldn't be executed because the premises wasn't occupied. I would be very careful about executing warrants without the owner, occupier or person in charge on the premises when you execute the warrant. Reason being, there will be allegations made that you have fabricated evidence, you have planted evidence, or you've been dishonest in the way that you execute the warrant. If it's absolutely necessary that you have to execute the warrant while the owner, occupier or person in charge is not there, I would obtain the assistance of someone independent. The best would be a justice of the peace. Get a justice of the peace to come along and be present with you when you execute that warrant. Similarly, I would video the whole process, right from the start of walking onto the front of the property as you come on to the property boundary, walking towards the building, dwelling or the premises. You need to protect your legal interests and the evidentiary value or the integrity of the evidentiary value of the evidence that you obtain. After you've executed the warrant, it needs to be endorsed with the name and address of the person on whom the copy was served, together with the name and identifying number of the inspector affecting the execution, after which you will take the executed copy of the warrant back to the court for filing. The court holds the warrants in the period of time between the execution of the warrant or the court order and the court case. So leading up to the court case, you will need to go to the court, get a copy or obtain the original warrant or court order, and you take that with you when you go to court for your prosecution. When you're conducting the search of the premises, secure the evidence. So if you're looking for documents, try and focus the first part of your search in areas where you're likely to find documents, an office, an area where there's filing cabinets, cupboards, things like that. Prioritise the search area for the places likely to reveal where the evidence is being held. Retain possession of the original warrant. Another thing to be very careful of. The warrant usually will only be allowed to be executed once. So once you enter the property as the office holder, the warrant holder, the case manager of the investigation, you need to stay on the premises until the search is finished. If you left the property, walked out onto the street to get something out of the car and come back, because you've left the property, the warrant execution is complete. So if you went out to the street, come back to the premises and continued searching, everything that you found or located after the period of time where you left the premises is inadmissible. So try and search methodically. I usually, when I execute a search warrant, start from the door to the room that you're going into or searching, and I search floor level, I search up to halfway up the height of the wall. Then when I go around and meet back at the door, I'll look at the second half of the room above the middle, and then lastly, the roof will be the area that you search. After you've searched, I usually get another team member to search the room again, just in case you may have missed anything. Have the owner or occupier present to assist and make comments on the evidence that's located. So when you're searching and you locate evidence, the first thing you should do is photograph it. Hopefully you will be videoing the process as well. And it's at that point where you say, I have now found whatever the item of evidence is. You ask the suspect to comment on the fact that you've located that evidence in their dwelling or their premises. Another good trick is to observe the suspect for the indication of the possible presence of evidence. There's two things that suspects often do. They will either stand in front of where the evidence is located in the event of trying to stop you looking there, or if they're in another part of the room, they may continually keep looking to the area as a means of reassurance to ensure that you haven't found it or haven't found the evidence that they've had secreted. So if you see the suspect looking in a particular area, go to that area and search it very thoroughly. When you locate evidence, you need to make notes and record where the evidence is located. So as I said before, take photographs of the evidence in situ, make notes, even to the point of in your notes, draw diagrams. I do that as well. On a search that covers a whole premises, and it's quite a comprehensive search of a premises, consider nominating a dedicated exhibit officer who may sit at a table somewhere in the premises, and they will take possession of and log any evidence that you obtain and keep it within the chain of custody and continuous custody that you need to provide, so that you'll get a successful prosecution when you go to court. Generally, there will be sensitised paper registers that you use or logs that you use when you're in the field. Sometimes some organisations, such as the Australian Federal Police, use a laptop and a barcode scanning system with evidence bags or audit bags, they call them, and they may provide a printout of the evidence that you've seized. If you don't have that and you have a book, I generally give a receipt to the person who's the owner, occupier or person in charge of the items evidence that's been seized. You need to video this process because quite often people will make a point of arguing or disputing what's been taken or what has not been taken. You must strictly comply with the terms and conditions of the warrant. May only seize items authorised by the warrant. You can't go on a fishing expedition. By that I mean we have case law here in Australia that allows chance finding. So if you're looking for example, documents and you find guns or drugs, that doesn't prevent you from calling the Federal Police or using the Federal Police to take possession of the guns or drugs and them taking action in regards to the offender or the suspect in respect to those items. What it does narrow you down to is you can't take a whole filing cabinet full of documents and then sift through them at your leisure. You need to search for the documents you're looking for on the premises and do that and only take what documents are relevant. Now, these issues should be specifically addressed in the pre-operational briefing before you go, and your team should be well aware of what needs to be looked for. Another issue that you may find, particularly in relation to documents, is a claim of legal professional privilege. And it usually relates to either doctors and their patients accountants and their clients, people like that. They may say you're not taking that information or those customer or case records because I'm claiming legal professional privilege. You as a government investigator, the only thing you need to know is that when someone lays claim for legal professional privilege, it relates to documents only, and you need to contact your organisational legal advisor, and they will arrange for an independent person to come and secure those documents, and then normally you will end up in the court making a decision as to whether it falls within legal professional privilege or not. The last thing you need to look at is consider withdrawing or not committing. Now, anything to do with safety, if you have savage dogs, if you've got an environment that has chemical hazards or any other thing that may cause you illness or injury, don't commit to the warrant. Go back and work out a plan B. Withdraw or disengage if necessary. Another common one is where the address is wrong. I have done a warrant where I thought, and I didn't check adequately, I thought the premises was number 12, which it was. However, when I arrived at the premises, it was 12A and 12B. It was a duplex on the one property. So I had to narrow down 12A, 12B. In cases like that, as I said before, there are usually paragraphs where you can obtain an emergency warrant. In that case, you might, at the scene of the premises, ring the court, get onto the justice or the magistrate that you spoke to, and get them to issue another warrant for 12A or 12B rather than number 12. And you'll get the paperwork and sort that out after the warrant's been executed. At the completion of the search, try and get the owner or occupier to sign an indemnity to release and acknowledge that no damage or injury occurred during the search. Again, the way you protect against this is by videoing the process. It covers your backside. It covers your backside well and truly, and no allegations can be made if there's clear video to see what has occurred.